Hi there, welcome to Logically Speaking, our live show talking about everything Florida law related to family law, criminal defense, or even just the business of law and running a business and having a law firm. Tonight's topic, we're going to talk about legal separation in Florida. Does Florida have it? Do they recognize it? And then what are your options regarding separating in Florida? So, in general, Florida does not have legal separation. They don't recognize legal separation. So, there isn't a way to file with the court or to notify anybody that you and your spouse are separated. There isn't any documents that say you're legally separated. So, in Florida, you're either married or you're divorced and single. There isn't a notification of legally separated. So that's the short answer on legal separation. But what if you and your spouse are separated, but you have children or have some financial needs that you need met? But for whatever, any number of reasons, you aren't ready to file for divorce. Do you have options? And the answer to that is yes, you do. Florida does recognize under the Florida statutes the ability to petition Florida courts for alimony, for child support, and for a time sharing and parenting and plan for children without a dissolution of marriage or a divorce petition attached to it. So you can take care of asking the court to provide potentially alimony if there's a need and an ability to pay alimony. You can ask the court for to determine. Many people commonly could talk about it as custody, but Florida doesn't use the term custody anymore. We refer to it as time sharing and a parenting plan. So you can ask the court to decide a time sharing and parenting plan, or you and your spouse can come up with one and file that as well. And you can ask the court to then also provide the child support guidelines and request child support after that time sharing and parenting plan has been established. And all of those things can be done outside of a dissolution of marriage. So, what does that mean for your marriage? Well, it doesn't really mean anything. You'll still be married, you'll just be separated, living apart, but you'll have a court order and established plan for alimony, child support, time sharing, parenting plans, and those things that you can petition the court for those petitions outside the dissolution of marriage. And if and when you are ready to proceed with your divorce, you can then come back to the court and petition the court for the dissolution of marriage and ultimately finalize your divorce. And then in that divorce would also be addressing any of those other outstanding issues that go along with the divorce, like the equitable distribution, whether or not the wife is seeking a name change, and any of those. And there's a lot of other items that go into a divorce, and all of those other items would be addressed then and the petition for dissolution of marriage. So the only things that can be addressed without filing for divorce so is a petition for alimony, child support, and then the parenting plan time sharing agreement that you can address separately without going forward and filing for a divorce if for whatever reason you are not ready to file for divorce at this time. So that is the nature of legal separation in Florida. I'm attorney Shiobhan Olivero, a Florida licensed attorney representing clients all throughout the state of Florida. Our number is there in the video, 813-654-5777 or info@oliverolaw.com. See you next time.